My name is Stephen Pressier, and I am one of two visiting scholars, as many of you know, in conservative law and policy this year. One of our jobs is to bring in speakers to share their wisdom with the Boulder community, and tonight we have brought in one of the wisest men I know, Mark Pulliam. I've admired Mark's work for more than 15 years. You'll remember we collaborated on a white paper in judicial selection for the Federalist Society back in 2003. Mark is now retired after many years as a partner in one of the country's great law firms, Latham & Watkins, in its San Diego office. He's moved back to Austin, Texas, where he attended law school, and where, I might add, he did brilliantly as an articles editor of the Texas Law Review. I think Mark is now best described as a freelance public intellectual.
There you go.
He churns out an amazing output of articles and commentary on the law and the Constitution. Mark is also a longtime member of the Federalist Society for Law and Public Policy, known to many of you, the most important group of conservative and libertarian lawyers. And he is the past president, I hope I've got this right, of the San Diego Lawyers chapter, and is now active in the Austin chapter. Mark is a contributing editor to the wonderful website, Law and Liberty, and his writing has appeared in the Wall Street Journal, the City Journal, the National Review, and many, many other publications. You can now access his writing through his brilliantly titled website, Misrule of Law, a chronicle of legal and judicial mischief. As some of you may know, I wrote a blurb for that website in which I stated simply, Mark Pulliam is one of the few truly fearless, devastatingly incisive, original, and yet deeply learned commentators on the contemporary legal scene. He was then, and he still is. I'm deeply delighted and deeply honored to have Mark with us this evening, and he will speak on the exploitation of labor and other myths. Please join me in welcoming Mark Pulliam.
Oh, thank you very much, Steve. After an introduction like that, I can only disappoint. So, well, I'm honored to be here at the University of Colorado, and I want to wish Professor Presser for the kind and brave invitation. He went out on a limb by inviting someone to lecture who is not a traditional academic. As he just mentioned, I'm a retired lawyer who now engages in legal commentary as a writer and a blogger. But when I was practicing law, my principal area of practice for 30 years was labor and employment. And I'm going to address some widely held misconceptions about that subject momentarily. I want to emphasize I'm not an academic historian, I'm not an economist, I'm not a scholar in the conventional sense, and I'm a writer and not a lecturer, so I'm a little bit out of my element. We're going to cover 7 myths, what I call myths, having to do with labor relations. And you could spend probably a full semester-long course on any one of them, but I'm going to kind of cruise through here at a 30,000-foot level. If anybody is interested or intrigued by any of these topics that I'm going to touch on, the full text of my remarks will be posted on my blog, Misrule of Law, which, you know, it's on the internet with all the other blogs, and with footnotes. And there are footnotes that go with this in case anybody wants to do any further reading on any of these subjects. So so what's the point of talking about labor unions in 2019? Well, I would say it's a very important topic and one that's poorly understood and is becoming less well understood all the time. A lot of the conventional thinking about labor unions is as a result of the New Deal. The New Deal, the 1935 Wagner Act, National Labor Relations Act, really made collective bargaining a legal obligation on the part of employers. And for many years, it was a very important legal discipline. It was taught, labor law was taught in all of the nation's major law schools. Some very prominent scholars specialized in teaching this subject. It was debated, not just in law schools, but it was a very important area of public policy. There were think tanks that specialized in talking about labor unions, pro and against. And unfortunately, the labor movement has sort of fallen into a state of decline in America. It reached a peak in the 1950s where about 35% of the private sector workforce was represented by labor unions, and now that has declined to less than 7%. So that's an extraordinary fall off. And then that 7% tends to be concentrated in certain parts of the country, in certain industries. Unions very rarely are winning any new representation elections, so their market share is declining, it's not growing. And if it weren't for the fact that these representation elections, once a union is voted in, it's not like a presidential election where after 4 years you have to vote again, that it's permanent until you can organize a vote out. So a lot of these bargaining units were put into place decades ago and are only there because representation is perpetual until there's a decertification election, which is somewhat difficult to accomplish. So even as labor unions have sort of fallen into obsolescence, at least in the private sector, all the rhetoric and assumptions underlying labor unions remains in effect. So it's basically some assumptions that never get questioned anymore, never really get discussed anymore. And so we just have sort of the vestiges of a narrative, but nobody ever really probes the narrative. And so, which is unfortunate because this narrative, a lot of it boils down to class conflict. That you have haves versus the have-nots, you got the workers versus capital. And this mentality, without a very firm background in the economics that underlie it, or the history that underlie it, or the legal aspects of it, or the governmental consequences of it, it's like a vestige that remains. And so I think it is important to go back and look at some of these topics that tend to be overlooked, and that's that's the subject of my remarks this evening. So my approach is that I'm a classical liberal, which means that I believe in individual rights, and my conception of a free society is when interactions between people, to the largest extent possible, are based on consensual economic exchanges, that people buy or sell things because they choose to, and on terms that they set through mutual agreement with whoever the participant is in the transaction. We move away from this paradigm and we get into the government coercing people to do things, or to telling them on what terms they have to do things, and that sort of is not the free society. That is a centrally controlled economy, and you sacrifice things like freedom and economic efficiency in the process. Now, our economic system is based on competition, and the idea is that buyers and sellers, business people, they compete, and by competing you produce the most efficient price, and this benefits consumers. Adam Smith's book, The Wealth of Nations, was the seminal statement of this school of economics, the foundation for what became known as capitalism. Now, because competition is so important, our antitrust laws forbid monopolies, price-fixing arrangements, and other restraints on trade. Businessmen cannot legally agree to set prices, divide markets, or otherwise collude in a way that would reduce competition. From an economic perspective, labor is indistinguishable from any other commodity bought and sold in the market. Wages are merely the price of labor, and in a free market, they would be determined by a consensual exchange between the buyer, which are employers, and the seller, employees, as a result of competition. So what are unions? Unions are not social groups or fraternal organizations like the Rotary or Kiwanis clubs. Formerly known as guilds, they are collectivized agents of workers, organized to obtain higher wages and more favorable working conditions than workers could obtain on their own through competition. How exactly does this happen? Unions essentially operate as cartels, fixing the price of their members' labor by internal collusion rather than by market competition, just like OPEC nations fix the price of a barrel of oil rather than letting the market set the price. OPEC is the Organization of Oil Exporting Countries, and not just the Middle Eastern countries. I think Venezuela is a member of this. And the whole purpose of OPEC is to get more for the oil than competition would produce. So when unions engage in this practice, internal price fixing, we call it collective bargaining. Now, like OPEC, unions threaten to withhold supply if the buyer does not agree to pay the fixed price. This is called a strike. Unlike OPEC, however, unions attempt to prevent other sellers who are not members of the cartel from selling at a lower price, sometimes with the threat of violence. This is called a picket line. Strikers not only collectively withhold their own services, which is consensual and is totally consistent with the precepts of a free society and with all the philosophy that goes with being a classical liberal, but what they also do is they seek to prevent other workers from crossing the picket line through force or coercion. Now, unions call these people strike breakers or scabs, but they are merely sellers willing to accept a lower wage, a function of competition and consensual exchange, which is entirely legitimate in a free society. Now think about this. If OPEC countries tried to blockade shipping to the United States to prevent the delivery of oil from non-OPEC suppliers, we would quite properly regard that as an act of war. But among unionized workers, the same behavior is celebrated as solidarity. The reason we have labor unions to establish what trade unionists often refer to as industrial democracy is purportedly to overcome the inherent inequality of bargaining power that is thought to exist between capital and labor. In fact, the legislative findings in support of the National Labor Relations Act say this. They say that since corporations can organize as entities with multiple shareholders, that labor unions ought to be able to collectivize with multiple workers. And this controversial notion has, which is ultimately rests on half-baked socialist premises, have dubious origins and has had far-reaching implications for labor law. Because this is a lecture rather than a semester-long course, I'm going to try to keep my subject somewhat general and try to avoid the weeds. So myth number one is that there is an inequality of bargaining power. The classical free market economics hold that workers sell their services to employers in a labor market in which the efficient wage rate is determined by competition among both buyers and sellers. The specific wage bargain that is struck will depend on the worker's perceived value to the employer and the existence of competing offers by other employers. In the world of free markets, the government's main role is to punish fraud, enforce contracts, and prevent collusions. Labor unions, which exist to facilitate collusion among sellers, are neither required nor encouraged in the world of classical free market economics. Critics of free market economics had a different view, sometimes radically so. And Karl Marx, who in 1848 wrote the Communist Manifesto, is credited with creating the theory of scientific socialism. There were writers before Marx who had similar thoughts about labor, but he's the one who synthesized all of this and certainly popularized it and turned it into a very formidable political movement. And in Marx's view, workers were inherently subject to the exploitation of capital, businesses, because in his view, the capital served no valid role, that the price of a product represented the labor value of the people who created it, and that to the extent that the people were paid wages that equaled less than the full price of the product, were being shortchanged, and it was the capitalist, the business owner, that was unfairly benefiting, that he was essentially a parasite and was depriving the workers of the full value of their labor. From a Marxian perspective, profiting from capital is illegitimate. It's equivalent to stealing. By retaining the surplus value of workers' labor, capital exploits the workers, an injustice that can only be corrected if the workers seize ownership of the business and therefore dispense with the parasitical role of capital. For Marx, class struggle, leading to revolution and seizure of the means of production, was the only way to prevent the exploitation of labor. Private property ownership is therefore incompatible with Marxian theory. Employment by a profit-making business, to Marx, constitutes oppression. This extreme form of socialism is the foundation of communism. Now, you can just imagine how militant workers would be if they sincerely believed Marxian rhetoric, as many did during the heyday of the Industrial Revolution. They were literally being incited to revolt and to overthrow the established order by force if necessary. By the late 19th century, as industrialism was burgeoning in America and continued in England, Marx's conception of socialism began to become associated in the public mind with violent anarchism, which was an unfavorable connection, leading non-revolutionary socialists to embrace a kinder, gentler version of Marxist theory, some versions of which predated Marx. This school of thought, symbolized by the Fabian Society in London, which was founded in 1884, became the basis for England's Labour Party and the London School of Economics. Some of the prominent figures associated with Fabian socialism include Sidney and Beatrice Webb, and in the so-called second generation, Harold Lasky, who was a lifelong friend and correspondent of Professor Presser's bête noire, the American jurist and renowned legal realist Oliver Wendell Holmes. Non-revolutionary socialism, or democratic socialism, inspired much of the 20th century labor union theory, which was sometimes aligned with a movement known as syndicalism. The more moderate brand of socialism did not call for outright worker ownership of the means of production, but emphasized the need for concerted action by employees to rectify the purported inequality of bargaining power between labor and capital, sometimes blamed on the ability of capital to organize into corporate entities, and to exercise some control of the business through union negotiations. Empowering workers in this way would, it was thought, prevent capital from earning excessive profits. This is the genesis of the modern American labor union movement and forms the gist of trade union rhetoric. In any event, is there an inherent inequality between labor and capital? The classical economic model holds otherwise. As long as there is competition between buyers and sellers and the absence of external coercion, the equilibrium price struck through voluntary exchange will represent the efficient market-clearing wage, favoring neither side. It doesn't matter, as a matter of economic theory, whether the buyer the employer is an individual, a sole proprietorship, a partnership, or a corporation. The principle of this is the same. Now think about this. Does an individual consumer have a disadvantage when he or she is shopping in a Walmart or an Amazon as compared to shopping in a Middle Eastern bazaar? Of course not. If anything, a modern consumer is going to get a better deal shopping at a corporate-owned entity than haggling with some merchant in a street in a Middle Eastern bazaar. As a matter of economics, labor is a commodity, and even though the 1914 federal law, the Clayton Act, said otherwise, that was simply a protectionist measure reciting the vernacular of socialist dogma. Depending on the employee's skill, experience, industry, and productivity, wage rates will vary across the workforce and across different industries. In today's economy, without union representation, some brand new lawyers now earn starting salaries approaching $200,000 a year. Computer programmers can demand valuable stock options from high-tech companies they work for. Welders and other trades in the oil patch, which is a big deal in Texas. I'm not sure if you have fracking up here in Colorado, but a lot of these welders are earning six figures. Hollywood stars, professional athletes, and recording artists sometimes earn tens of millions of dollars annually or more. Judge Judy makes $47 million a year, more than any other TV host. LeBron James, who never attended college, recently signed a 4-year, $154 million contract with the LA Lakers. 26-year-old free agent Manny Machado just signed a 10-year deal with the San Diego Padres worth $300 million. Another ball player, Bryce Harper, recently inked a deal with the Philadelphia Phillies worth $330 million over 13 years. Where's the inequality of bargaining power? In a free society, compensation is determined by supply and demand. Some people's labor is more valuable than others and is worth more money than others. The notion that labor is fungible, that individuals are inevitably at a disadvantage vis-a-vis corporations, and that employment is inherently exploitative is a vestige of Marxian theory that has been discredited by history. Yet, this is the theoretical foundation of the National Labor Relations Act. The second myth I'm going to talk about is that capitalism oppressed workers. And this sort of goes hand in hand with the exploitation theory. So why then does the mythology of industrial democracy persist? There are many explanations, but in keeping with my iconoclastic theme, I will contend that it aids the political left's self-serving defense of rent-seeking by one of its major constituent groups, workers. Unions are a core member of the Democratic Party's political coalition. Class conflict is a favorite theme for liberals. The left has developed a narrative that the rise of capitalism, and particularly the Industrial Revolution, resulted in the oppression of workers, but I contend this is false. Capitalism liberated the long-suffering peasant class. Ever since the advent of the Industrial Revolution, beginning in England in the late 18th century, a population that had for centuries subsisted, sometimes barely or not at all, primarily on labor-intensive agricultural production, increasingly became engaged in factory production. This was a momentous shift. Technology, enabled by capital investment and the profit motive, transformed the economy. Factories, machinery, innovation, and inventions, including the steam engine, wrought dramatic social changes. These developments concentrated workers in centralized activities and shifted the population mix from rural to urban locations. Cities grew rapidly, trade expanded. People often relocated to pursue opportunities, and the sheer number of people vastly increased due to sharply declining mortality rates. Even though industrialism in the long run improved workers' standard of living significantly, which is a relative improvement made all the more dramatic by the squalor, hunger, disease, and poverty that afflicted most people in the pre-industrial era, living in closer quarters and observing the prosperity being enjoyed by the emerging business and professional classes, or the bourgeoisie in Marxian terms, created tensions and resentments. Unionism was primarily a manifestation of workers' dissatisfaction with relative inequality. While wage-paid factory workers, the proletariat in Marxian terms, were generally better off than prior generations of serfs or tenant farmers or miners or wool spinners and weavers who had barely eked out a living by piecework, they saw others with more and were prompted to demand a greater share for themselves. Increased class consciousness and the proximity of large groups of similarly situated workers begat industrial discontent. This ultimately explains the rise of unionism in England and in the US a century later when the industrial age came to America. As a matter of history, the oppression of the working man as a result of the Industrial Revolution was instead a steady improvement in the average standard of living, along with a declining incidence of child labor. In the US, average real wages grew significantly to substantially in the decades 1860 through 1910, an era of large-scale immigration, immense capital investment, and technological change, while the percentage of the labor force that was unionized was minuscule. This is exactly the opposite of what the exploitation theory would have us believe. The main goal of unions then and now is to artificially increase economically efficient wage rates and simultaneously to reduce productivity by threatening to disrupt the employer's operations through strikes and other forms of work stoppages. The third myth that I want to talk about is that employers were wrong to resist unionization. Now, there's never been any law that says that employers couldn't recognize and negotiate with unions if they wished to, but what the National Labor Relations Act did in 1935 was to require this if unions jumped through certain hoops and demanded an election and won an election. And the notion was, well, that employers should be required to recognize the unions and to collectively bargain with the unions because somehow it's wrong not to. And the question is, well, why do we think that it was wrong for them to have the right to refuse to recognize unions or to collectively bargain with unions? Well, union advocates often cite as evidence of industrial oppression the resistance of employers to unionization, which they claim was typically characterized by violence. The violence we're going to get to in the next myth, but let's just talk about resistance, that workers say, we formed a union and we demand that you negotiate with us, and the employer says, no, I don't want to. What's wrong with that? Well, Congress cited the refusal of some employers to recognize unions and to engage in collective bargaining as a justification for enacting the NLRA, National Labor Relations Act. It is a fallacy to assume that employers violated employees' rights simply by declining to accede to union demands. Prior to the New Deal, and in particular the National Labor Relations Act, businesses could operate largely as they pleased, subject to antitrust laws and common law rules. A unionized workforce was legitimately viewed as a serious impediment to operating a profitable business. It is entirely understandable why a factory owner, then and now, would oppose unionization. A union claiming to represent the workers would typically demand higher wages and more generous benefits for a shorter work week, with protections against layoffs and restrictions on operations. Employers understandably viewed such demands as meddlesome interference with their business and refused to negotiate with the unions. Agreeing to such terms would raise labor costs, placing a business at a competitive disadvantage vis-a-vis other firms. Even small differentials in costs between firms could be ruinous. When the union struck, that is, engaged in a concerted refusal to work and usually interfering with the ability of other workers to take their place, employers hired private security and understandably made sure the replacement workers could fill their jobs. This response is neither unreasonable nor morally objectionable. During the Gilded Age, and even as late as the 1930s, many employers conditioned employment offers on employees' agreement not to join a union. These arrangements are pungently referred to as yellow dog contracts, on the grounds that signing such a pledge supposedly reduces a worker to the status of a yellow dog. You'll notice that union rhetoric has come up with these terms, yellow dog contracts, scabs, which are very colorful but has the effect of deflecting attention away from the intellectual content of what you're talking about and instead turning it into a label that, if somebody's a scab, well, of course they're undeserving because scab is such a unsightly figure of speech. Well, but yellow dog contracts are really the flip side of closed shop agreements, which limited employment to union members. And the closed shop had long been one of a union's demands. They would try to get employers to say, you can only hire members of the union. And these types of arrangements were not prohibited until 1947. There's nothing intrinsically wrong, let alone immoral, about employers requiring workers to refrain from union membership as a condition of employment as long as they are consensual. Again, nobody's forcing workers to work for any particular employer on any particular terms. So let's turn now to the fourth myth, that employers were primarily responsible for violence in labor disputes. While it is true that many labor conflicts were violent, especially during the tumultuous late 1880s and early 1900s, at the peak of the so-called Gilded Age, labor unions were responsible for most of the violence. Violent conflict was most common when replacement workers, or scabs, tried to cross the picket lines as they had a legal right to. The very term scab expresses the extraordinary contempt that union sympathizers had for workers who did not share their collective goals, i.e., who were willing to work on terms that the union refused. Much is said about employers hiring private security forces, such as Pinkertons, to provide security, which they did in the absence of adequate local police forces to protect their property during that time. But one must not overlook the militant leadership of many labor unions during this era, which included a radical faction of socialists, communists, and anarchists who sought to overthrow the capitalist system. Unionists, many of whom embraced the Marxist conception that private ownership of business was illegitimate, were willing to and did resort to extreme measures. Bombings were not uncommon. Let's take a quick look at one of the most notorious labor conflicts, the May 4th, 1886 riot in Chicago's Haymarket Square, in which 8 people, including 7 Chicago police officers, were killed when someone threw a bomb into a crowd of policemen who were breaking up a protest rally. Conventional wisdom holds that xenophobia and anti-union hysteria led to an unfair trial resulting in the conviction of 8 foreign-born anarchists, 4 of whom were hanged, a travesty of justice, according to historians sympathetic to the labor movement. I would recommend that you read Timothy Messer Cruz's scrupulously balanced account, The Trial of the Haymarket Anarchists, for an alternative version, based on a review of the actual trial transcript previously unexamined by historians. His assessment: the investigation was thorough, the lengthy trial, which lasted 6 weeks, was fair, the evidence was overwhelming, and the jury verdict was sound. If you look at the history of labor unions in America, you will find many radical outfits that advocated and engaged in extreme violence, including the Industrial Workers of the World, sometimes referred to as Wobblies, the Iron Workers Union, which was responsible for bombing the LA Times building in 1910, the Western Federation of Miners, which was charged with assassinating Idaho Governor Frank Steunenberg in 1905, and the United Mine Workers, which led an armed resurrection in West Virginia in 1920 and 1921, resulting in up to 100 deaths before being suppressed by federal troops. The Pullman strike and boycott in 1894 was a violent affair led by socialist Eugene Debs, then president of the American Railway Union, who was imprisoned for defying court orders. And there are many others. Now, I don't wish to suggest that employers were always blameless or that peaceful picketers were never the victims of violence, only that both sides bear responsibility. Unions have never hesitated to resort to force or physically to interfere with the employer's business operations, often in violation of the law. Many people don't know this, but it's a fact, it's easily verified, that the UAW obtained General Motors recognition in Flint, Michigan, not by an NLRB-sanctioned representation election, but by staging an illegal sit-down strike in 1936 and 1937 and defying federal court orders that they vacate GM's premises. Now, a lot of people who are sympathetic to the labor movement tend to look back at the period, the working conditions during the Industrial Revolution, and say, well, the people were so poor, that the living conditions in New York City were so bad that there had to have been exploitation, there had to have been oppression, or else people would not be living like that. And this is called presentism. That is the tendency to look back on past periods through the lens of today and to judge the past by the standards of today. And what we have to remember is that the immigrants who were working in mines, employed in sweatshops, or living in urban squalor were escaping even worse living conditions in their country of origin. They came to America in unprecedented numbers to escape famine and misery. The working conditions they encountered in America were an improvement, and that is why so many immigrants came here and continued coming. Okay, myth number 5 is that courts in America improperly issued injunctions against unions. There was a period in American history where employers availed themselves of legal remedies for union misconduct, such as engaging in violence, forcibly interfering with the employer's business, and preventing willing workers from performing services during a strike. Before federal labor law was passed in 1935, drastically altering the legal landscape, state law governed the employment relationship and in many cases regulated conduct deemed to constitute common law restraints on trade. Employers could and did file lawsuits against unions when they violated other people's rights, and sometimes employers obtained injunctive relief against union conduct. An injunction is a judicial order forbidding certain conduct. Now, this came to be called government by injunction, which is little more than a political slogan, which the Democratic Party platform opposed as early as 1896. After an abortive effort at reform in 1914, union pressure ultimately led to the enactment of federal legislation in 1932 forbidding federal courts to issue injunctions in labor disputes in most cases. This law is the Norris-LaGuardia Act. And the Norris-LaGuardia Act is now regarded, along with the Wagner Act, as part of the Magna Carta of organized labor. But was the era of government by injunction myth, or was it fact? The late Professor Sylvester Petro, who taught labor law at NYU and Wake Forest for decades, argued that it is a myth. He did this in his book, The Labor Policy of the Free Society, and in much greater detail in a series of law review articles published in the Wake Forest Law Review and the North Carolina Law Review from 1978 through 1982. Petro went back and reviewed every reported state and federal labor injunction case during the period 1880 to 1932, and there were 524 reported decisions. And he also reviewed 145 unreported labor cases to determine if the courts acted in accordance with traditional principles of equity. Petro concluded, based on his exhaustive research, that on the whole, courts faithfully followed the well-established common law rules and relevant procedures. Rather than finding class bias in favor of employers, Petro found that courts most often ruled in favor of non-union workers willing to accept employment on terms that the union employees had refused. That is, the courts protected the right of scabs to work during a strike. Specifically, Petro concluded that not one primary strike for better terms and conditions of employment was ever finally enjoined merely as such. The same is true for peaceful primary picketing and other forms of strictly peaceable persuasion. Courts only granted relief when such conduct was intertwined with violence. Unlike merchants and manufacturers subject to antitrust laws whose collusion violates the law, peaceful wage fixing by labor cartels in the guise of collective bargaining and other concerted activity has never been proscribed, at least in America, since 1842. Labor unions complain about employers' legal abuses, but themselves enjoy remarkable privileges under federal law. The sixth myth is that the model of collective bargaining used in the Wagner Act is beyond reproach. The Great Depression wrought the New Deal, and FDR's brain trust engaged in a number of bold experiments, including the Wagner Act, passed in 1935. The New Deal is now often regarded as inevitable and visionary, but in reality it was haphazard and messy. Some of it, such as the central economic controls represented in the National Industrial Recovery Act of 1933 and the Agricultural Adjustment Act of 1933, both of which were declared unconstitutional, were plainly borrowed from Mussolini's corporatism. We tend to view our current model of collective bargaining as preordained, consistent with other nations' practices, and beyond reproach, yet it rests on some unique and highly controversial features. One of the central features of the Wagner Act is the concept of exclusive representation. And what exclusive representation means is that when a majority of employees in a given unit or department vote in favor of union representation, the employer is required to recognize the union as the exclusive representative for all of the employees in that department, even the employees who did not wish to, who voted against union representation. So if we had a department that had 100 employees, you had an election, 51 selected union representation, 49 voted no. Once that union is certified as the bargaining representative, the employer has to recognize and negotiate exclusively with the union on behalf of all 100 employees, even the 49 who voted against it. And those 49 employees have no legal right to talk to the employer separately to try to get better wages, bonuses, whatever. The union becomes their exclusive voice. And former Harvard President Derek Bach, who was also a labor law scholar, wrote an article in the Harvard Law Review in which he noted the uniqueness of exclusive representation in the United States. One significant consequence of exclusive representation is that it forces the minority to accept the terms negotiated by the union, which unions call being a free rider, but more accurately amounts to being a forced rider. Unions cite the free rider phenomenon as a reason to be able to force the minority to join the union or to pay the equivalent of union dues, called agency fees, as a condition of employment. But if union representation were voluntary, there would be no free riders. The free rider issue and attendant controversies over union elections the duty of fair representation, mandatory union membership, and the payment of dues has led to considerable litigation before the National Labor Relations Board and in the U.S. Supreme Court, and the passage of so-called right-to-work legislation at the state level. In the public sector, the free rider issue produced 41 years of controversy over the First Amendment rights of agency fee payers, which was finally resolved last year in the case of Janus versus AFSCME. And this is all because of the concept of exclusive representation. Now, the last myth that I'm going to talk about tonight is the most outlandish of them all. And this is the myth that government employees should be allowed to unionize also. Collective bargaining was not legally required in the United States until the National Labor Relations Act in 1935, and even then it was limited to private sector employees. Recall that the rationale for unions was to rectify the supposed inequality of bargaining power between employees and corporate employers, to level the playing field for capital and labor. Unions seek to obtain a fair share of the employer's profits through labor negotiations. At the time, even New Deal liberals, such as President Franklin D. Roosevelt, viewed government employees as a fundamentally different situation. Government employees were thought to be public servants, not part of an economic struggle. The New Dealers were right. The government represents the citizenry, not investors. The government does not generate a profit. The amount of compensation paid to government workers is a political decision, not the product of economic competition. In a democracy, we elect representatives to allocate finite taxpayer resources among various needs: public safety, roads, education, parks, etc. Paying taxes is not optional. In the private sector, if you have 3 or 4 businesses selling the same product and one of them is unionized and there's a strike, consumers can purchase the goods and services they need from other providers. The government has a monopoly on providing government services, and paying taxes is not optional. So FDR and other New Dealers rightly thought that the right to strike was totally incompatible with government employment. In FDR's words, it's unthinkable and intolerable. Public sector unionism, I submit, is indefensible. It is rent-seeking and nothing more. That was then. Even though the NLRA did not cover public employees and still does not, beginning in the 1960s, the growing number of government employees at the state and local level lobbied for and obtained collective bargaining rights, and in some cases the right to strike, from state governments. Because unionization in the private sector is constrained by economic competition among employers and even among different countries, witness the collapse of the U.S. auto industry in the face of foreign competition, especially from Japan, employers have an economic incentive to resist union organization. Notwithstanding the one-sided rules governing representation elections favoring unions, the global economy has steadily reduced the portion of the private sector workforce in the U.S. that is represented by a union. In contrast, the public sector faces no such constraint because government has a monopoly and taxes are compulsory. Government employers have no economic incentive to resist union organizing and sometimes even encourage it. Labor costs are simply passed through to taxpayers. Taxpayers have no choice whether to pay. Consumers of government services at the state or local level have no marketplace alternatives other than moving elsewhere. The public is terribly vulnerable to strikes by government employees. As one might expect, for all of the reasons that I've cited, the rate of union membership in the public sector has steadily grown. Government employees now account for about half of the total union membership nationwide. Public employee unions undermine democracy by using union dues to help elect candidates to state and local office who will be sympathetic to their demands. These candidates, once elected, sit across the bargaining table from the unions who got them elected. The negotiations are a farce. The unions write their own ticket with the taxpayers, having no one representing their interests footing the bill. The result is inflated government payrolls, excessive salaries, and public employee pension benefits so generous, sometimes bordering on plunder, that many state and local governments are deeply in debt, and some are on the brink of insolvency. It is now taken for granted that government workers, teachers, police officers, firefighters, and the rest should have the same rights as their private sector counterparts, without considering that the inequality of bargaining power has absolutely no application to public servants. FDR knew better. All right, so in conclusion, in all of these areas, each of these 7 myths, fashionable opinion has had a tendency to harden into orthodoxy. Prior to this lecture, many of you may have heard from only one perspective, the pro-union position. It is my hope that some of you may be provoked to question that orthodoxy, which sometimes borders on mythology. The full text, as I mentioned, of my remarks with footnotes will be posted on misrule of law in the next couple of days. If you are curious, please use it as a roadmap for further inquiry. And with that, I'm done, and thank you. And I think we have time for questions. Yes.
Okay, thank you. I have 2 related questions. I was a little confused. What do you mean by profit? And why does profit necessitate private property?
What is profit?
I'm confused as to why you only have to profit with private property. That's at least what I took away.
Well,
because, for example, when you're talking about the government, you don't get profit. Right?
oh, okay,
So I'm confused.
right.
Yeah.
Okay, so the whole concept of collective bargaining and the legal obligation to negotiate with workers started in this country with the notion that, due to these sort of Marxian notion that workers were inherently oppressed vis-a-vis capital, that they needed to have a louder voice. They needed to be able to operate in concert. In the government context, we don't have this economic warfare between labor and capital. The government serves as a conduit for the public, voters, taxpayers. So in Colorado, the voters have to decide how much money we're going to spend on roads, how much money are we going to spend on the University of Colorado campus, how much fire protection, how much police protection. Those are political decisions. Those are not the give and take of capital versus labor, struggling, industrial democracy, making sure that the business is not earning an unfair profit. The government isn't earning a profit. The government is serving as a conduit for taxpayer resources that are extracted from people through compulsion. So, of all of the myths, the one I hope you find the most, the debunking of which I hope you find the most persuasive, is the idea that public sector unionization really has nothing, is completely unsupported by the theoretical assumptions that gave rise to the American labor union movement to begin with, because there is no tension between labor and capital when you are merely allocating government resources through the political process.
Yeah, I'm still confused about, maybe I just don't understand profit, but why? Because at least when you talked about myth 1, you kind of connected private property with profit.
Right.
And I'm still not, I don't get why that is.
Well, so Okay, so a business owner, so the evolution of the economy from the agrarian economy that had existed for centuries, for thousands of years, up until the advent of the Industrial Revolution, is people worked out in the field and raised crops, and if you owned your land, you got to keep what you raised. If somebody else owned the land, you had to share your crop with them, and it generally produced, and a lot of these people were peasants, were serfs, okay, and the standard of living was very low. Then we had the advent of industrialization. Capitalism sort of came to the fore, and people built mills, and to build the mill, you had to have resources, capital, money, you invested. And we only had, and these capitalists, these entrepreneurs who built the mills, were only able to do so because of private property. They were able to amass this capital, invest this capital, and earn the fruits of, if the business earned a profit, they got to keep the profits. Not all businesses were profitable, not all investments turned out to be profitable. But because of this incentive that people had, because of the concept of private property, of being able to earn a profit, people engaged in risk-taking, and risk-taking encouraged innovation, and innovation led to things like the discovery of an enormous amount of inventions during the industrial era. The steam engine, which before then, you got around either by foot or on horse, but steam engines permitted railroads, permitted ship traffic that wasn't dependent on wind, etc. So private property is the one of the essential elements of a free market economy that sort of created the Industrial Revolution. And the Industrial Revolution had the effect, people didn't go from squalor and misery to a comfortable standard of living overnight. It took 100 years, but from the time that industrialization really took hold in the United States shortly after the Civil War up until the early 20th century, there was a significant improvement in the standard of living, which is a result of business owners, by virtue of the institution of private property, investing money in technology and steel mills and railroads and other things. So that's what kind of created the industrial age. And so throughout this period, there was some sentiment that workers were at a disadvantage vis-a-vis capital, and that they needed to be given a special tool to help them, the right to organize into unions and engage in collective bargaining. And they eventually persuaded the federal government during the New Deal to extend them those rights. And but the last myth is that even if you assume that the logic behind that for private sector employees who need to be able to engage in this activity to make sure that the capitalists, the businessmen, are not earning an unfair profit at their expense, none of those assumptions transfer over to the decision of how much we're going to pay our teachers vis-a-vis, as compared to police officers, compared to firemen, compared to spending on parks, schools, etc. Yeah.
So first, thank you for a very thought-inspiring talk. It strikes me that perhaps the construct of classic liberal economic political theory is not complete. There's an observation during forming that any theory succeeds not by what it explains, but by what it excludes. And here is a sense of what it may exclude, and that I think may need some rebalancing. So ironically, the Estonian Socialist Republic, in creating its constitution, when it was breaking off from the Soviet Union. The first declaration was that we believe all human beings are created with equal dignity. Now, most of us would not disagree with that. But when you try to push that into a question of what does that mean? How much economic resource do you have to have dignity? It's an interesting question. So, undeniably, in the period of Union ascension, there was equality, maybe less inequality than in Tsarist Russia, and maybe less equality than in the primordial laws, but still inequality. And I think that's what the Union movement was in part addressing. And whether or not it offends classical liberal economic theory isn't the point. It's addressing an obvious fact to these people. Would you rather be the czar or a serf? Would you rather be the executive of Walmart or a Walmart employee? That's the political discussion, I think. Not that it offends classic liberal economic theory.
Well, you're right. The thing about equality is that we are equal before the law, but we're not all equal in aptitude, ability, industry, ambition. And so one of the clear...
Dignity has some economic implications.
Okay, so yeah, I mean, so you can kind of use dignity as sort of a euphemism for end result equality, but end result equality has never really been compatible with the precepts of individual liberty as we understand them in the United States. You know, we permit some people to be more successful than others as long as people are not being artificially hindered, and so the explicit goal of collective bargaining, and this was in the Supreme Court decision that upheld exclusive representation. They said so, that Congress created Section 9A of the National Labor Relations Act to collectivize the workplace so that people who had advantages over their coworkers because they're more capable, they're more skilled, they're more hardworking, should not be able to profit individually from that we're going to treat everybody the same. I think most people in America, if you kind of pose it to that should we impose equal outcomes on everybody, I mean, this is like the Kurt Vonnegut short story Harrison Bergeron, that some people are better looking than others, some people are more athletic than others, some people are more intelligent than others. Are we, in order to maintain the dignity of everybody, to somehow prevent people with superior attributes from performing to the extent of their ability? You impose mediocrity that way.
No, Professor, it is a different argument. It isn't arguing for absolute equality. It's a different question. It's for you personally, say, and I very much appreciate your very informed, intelligent remarks and don't disagree with it, but you personally, how much economic disadvantage would you suffer before you say it's affecting your human dignity? And there is a level of that. If you could not feed yourself, if you could not eat, if you could not eat your family, that's an assault on your dignity. That's the political discussion.
Well, and I think in the United States, the welfare state has progressed way beyond what was in place at the time of the Great Depression, and so maybe we address these things with welfare programs rather than by collectivized wage bargains in the workplace. I think one of the most shocking and striking things about the federal labor law is how it has tailed off into almost obsolescence, that fewer than 20% of employees are currently represented by labor unions in the private sector compared to its peak. So only less than 1 in 5. And it's not because labor unions aren't trying to organize people, they still are. People are not choosing union representation. Why not? That when labor unions were introduced in America, We did not have minimum wage legislation. We did not have maximum hours legislation. We didn't have protections against discrimination, Title VII, all of these things. The whole safety net, social safety net was created, a lot of it during the New Deal, but a lot of it in the Great Society. So we have now a welfare state that kind of ameliorates some of these economic inequalities, and we don't rely on regulating the workplace in order to accomplish that. You had a question?
Yeah, so this is a bit related to that actually, but early on you were talking a lot about efficiency, and it seemed kind of that that was your main criterion for whether or not something was desirable, was whether it was an efficient outcome. And so I was just wondering how you kind of arrived at that to the exclusion of maybe some other factors, maybe not like strict equity, but just, I was wondering kind of how that, you think of that as the most important.
Well, like I said, I'm not an academic economist, so all I was providing was like a thumbnail, very superficial account of free market economics. And so the sort of the rationale, one of the rationales for free market economics is that you start off with, everybody owns themselves, self-ownership, that's sort of inherent in the Declaration of Independence. And if you own yourself, you own the product of your labor. So that's how you sort of get to private property. And then you have a free market exchange. That's not the only way you can operate an economy. You could operate an economy like Venezuela does, where they don't have electricity, they don't have potable water, they're slowly starving to death, people are fleeing. Or you can have, as your paradigm, and of course it's just a paradigm, but free market economics, where the notion is, the theory is, that when people are transacting, buying and selling goods through voluntary exchange, every transaction is consensual. So if you want to buy something from a merchant for $2, the merchant values your $2 as being more valuable than the croissant or the cup of coffee or whatever it is he's selling, whereas you are viewing the cup of coffee or croissant as being more valuable than the $2. So you pay the merchant the $2, you get the cup of coffee, you both consider yourself better off. That is maximizing consumer welfare. And there's a whole body of thought, from Hayek and Milton Friedman, et cetera, which talks about how not only does this maximize consumer welfare, which in economic terms is considered economic efficiency, but that you also are allowing this price system to operate, that there are these cues that operate. How much coffee should the merchant make? What type of croissant should he offer? And this is all dictated not by some central planner who decides in advance, how much coffee there should be or how many croissants or what kind of croissants, but by the preferences of consumers as expressed in the marketplace. So, now you could point out, well, the marketplace is not perfectly efficient, there's imperfections, and there's transaction costs, and yada, 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 and that's all true. And so there is no perfectly efficient market, but we, I think, are all better off if we, at least as our starting place, we assume that consensual economic exchanges produce a better outcome than the alternative of some sort of centrally controlled or command from a planner who, where you end up with shortages and rationing, etc. Yes?
Would you apply this to the Uniform Practice of Law rules that exclude non-lawyers from doing many things that individuals could do for themselves? And the bar being the ultimate labor union that is very exclusive and it's a non-governmental entity. Would you get rid of all the UPL laws?
I think we need to recognize that the bar is a cartel. I mean, and when I said that the labor unions, used to be called guilds, and that went not just of groups of workers, but professionals. And so, no, I agree from an economic standpoint, a lot of the regulation of the legal profession is not for the benefit of consumers, but it's for the benefit of lawyers by restricting supply, making it more difficult to compete. And lawyers are very savvy about using the government to enforce these restrictions. And just to show you, I'm not a hypocrite about this, about a week ago, a lawsuit was filed against the State Bar of Texas, claiming that under the authority of the Janus decision, it's illegal to compel lawyers to pay dues to the State Bar of Texas, which engages in some licensing and so forth. I think you can make a case that the government should make sure that people who are practicing law are competent, that you should have to prove you're competent somehow. But a lot of what they do, particularly the lobbying and political activities, they fund with mandatory payments, which are just like union dues. And I'm proud to say I'm one of the 3 plaintiffs in that lawsuit.
What about UPL laws?
I think that LegalZoom and paralegals and so forth ought to be available to consumers to a far greater extent than they are now. There's a lot of things that you depend on lawyers to do, basic legal documents, wills, etc., that cost a lot more than they should, and that, again, I think some consideration has to be given to make sure that consumers aren't being misled, that they're not being defrauded. But beyond that, I think I'm all in favor of competition and consumer welfare, and so I know lawyers are held in low esteem by a lot of the public, but and I generally share that perception for a lot of the same reasons. Yes.
First of all, thanks for the talk. It's great to hear these ideas so eloquently organized and expounded. We don't hear them enough. To go to a super basic foundational point about workers and capital and whether or not they can ever really negotiate on even grounds, that I agree if the workers really stood up for themselves and were confident in their worth in the situation, that a lot of these situations could work themselves out. The issue is that the employer, because of their situation, they have the ability to hold out, to refuse to hire somebody, to have a help wanted sign up for a long period of time, to let people go, whenever they feel like it's the right choice. Whereas the people seeking employment have a much harder time going long periods of time between work. If they lose the job, they have to totally upend their lives. To seek something else, they might have to move, they might not be able to pay bills, because many workers live very much hand in mouth in a way that most employers just don't on a day-to-day basis. So,
Yeah.
Isn't there an inequality there?
If we were living, in 1850, and the only jobs that existed were, factory jobs in some kind of textile production, and literally all the jobs were fungible, unskilled labor, I think you'd have at least you'd have the kernel of an argument. And it was at the early stages of the industrial era that a lot of this union rhetoric really took hold. People didn't know what to make of it. It was a huge disruption to the status quo, and people feared the power of these employers, and the idea of working in a factory was, dehumanizing, and so on and so forth. But in 2019, that's not the economy that we have. And I'll say this, as somebody who spent 30 years advising employers, the average employer in America, so there is this notion that, well, employers have the power to act arbitrarily, and therefore they will act arbitrarily. Just because you have the power to act arbitrarily doesn't mean that you will exercise that power, because there's a lot of market constraints that suggest that you do otherwise. So employers spend an enormous amount of time recruiting good employees. And good employees are hard to find. And then once you've obtained the good employee, training the employee so that they perform at a maximum level and benefit you. And that if you are a motivated employee that is punctual and reports to work, is not habitually absent, you are the rare employee. Your employee values you. And they will go to extraordinary lengths to retain you because of the difficulty of finding replacements, training replacements, etc. So one of the myths, I could sort of probably come up with a half dozen more myths, but one of the myths is that we need all of this infrastructure of job security legislation, wrongful discharge protection, employment discrimination. We need all these laws against sexual harassment in the workplace and so on and so forth to prevent employers from exercising this arbitrary power. And in my experience as an employment lawyer, that these laws, once you put them into place, serve one purpose and one purpose only, and that's to provide an excuse for mediocre, underperforming employees who are trying to evade the consequences of their own poor performance and to cite, oh, the reason you're doing this to me is because I complained about this or because I'm a member of this protected group or not. Employers in America, at least based on my experience, the last thing they want to do is to act arbitrarily if it's going to cost them the benefit of having a good employee, a well-trained employee, because it's in their economic interest to keep those employees. Because if you fire somebody for arbitrary reasons, that person's going to go to work for your competition and they're going to hurt you. So you want those people working for you. And a lot of people have this suspicion about our free market economy. And you certainly see it in the degree of attraction that a lot of millennials have towards this rhetoric of democratic socialism, is that without democratic socialism, we're going to be worse off. Well, and I'm not just here as an apologist for the free market system, but I am a big proponent of the free market system, is that the free market system has done more to benefit mankind and to improve living conditions and quality of life for people in countries that enjoy that system, and that it, just because theoretically employers could act arbitrarily, overwhelmingly, almost without exception, they do not. And if you're interested in this particular area, Richard Epstein, who for a long time taught at the University of Chicago, now he teaches at NYU, he's a libertarian, and he's written extensively just on this subject. And he is a complete critic of not just labor unions, but of all of this statutory regulation of the workplace. And he makes a very powerful case how employers are rational, and rational economic actors do not take arbitrary actions that's going to hurt their own position, and that the discipline of competition in a competitive marketplace is the greatest protector that employees have against arbitrary and unfair conduct.
On that extraordinary high note, let's go into informal session. There should be some refreshments. And thank you very much, Mark.
All right, thank you. Thank you.